principles on which the model law is based. The fact that uniformity in interpretation had always been contemplated in the framing of the model law perhaps explains why Article 2A was the subject of almost no discussion within the working group or in the process which led to UNCITRAL's revision and adoption of the amended model law. What can be inferred is that at least part of the thinking laying behind its insertion was that highlighting its international origin and the need to promote uniformity in its application in the text of the model law would serve as a reminder to courts and practitioners alike of the desirability of striving to arrive at internationally consistent interpretations of the model law. As one commentator on Article 2A explained it at the time, the model law's basic objective and purpose are better served by the internationalist interpretive approach, as the adoption of such an approach will significantly reduce the risk that domestic courts will interpret and apply the model law's provisions in idiosyncratic and counterproductive ways. From the adoption of the updated model law at the international level, it then again fell to each state to decide whether to make commensurate amendments to its domestic legislation. That brings me to stage 4, domestic integration and reinterpretation of the updated model law. Here I turn from a broad survey of international and transnational developments to focus specifically on developments in my home jurisdiction of Australia following the international updating of the model law in 2006. By way of background and explanation, I need to point out that Australia has a federal system of government. The system comprises the Commonwealth of Australia at the national level, together with 6 states and 2 self-governing territories at the sub-national level. As I previously mentioned, the Commonwealth Parliament had enacted the model law to govern international arbitrations as early as 1989. Following the international updating of the model law in 2006, the Commonwealth Attorney-General in 2008 announced a review of the existing International Arbitration Act. The result was the enactment in 2010 of the International Arbitration Amendment Act, which made clear that the model law, given the force of law in Australia, is the model law as amended in 2006, and which also removed the ability to opt out of the model law, instead providing that the model law is the law that applies to international commercial arbitrations in Australia. The Attorney-General said at the time of introducing the 2010 Amendment Act that the Commonwealth Government understood the benefits consistent jurisprudence would bring to the facilitation of international arbitration in Australia. Domestic arbitration in Australia, on the other hand, continued into this century to be governed by state and territory legislation formulated in the latter part of the 20th century, which operated without reference to the model law and which was being revealed by the early 2000s to be increasingly unfit for purpose. The Chief Justice of New South Wales, James Spiegelman, went on record in early 2009 saying, and I quote, "Our uniform legislative scheme for domestic arbitration is now hopelessly out of date and requires a complete rewrite." The review process which preceded the 2010 amendments to the International Arbitration Act provided the opportunity for the sparking of that wider reform. The Chief Justices of the states and territories wrote to the Commonwealth Attorney-General during that process, saying that it would not assist Australia's position in relation to international arbitration if the law with respect to domestic arbitration develops in a significantly different manner. In line with this view, the Standing Committee of Attorneys General in Australia agreed to develop a new domestic uniform commercial arbitration legislation to be based on the UNCITRAL model law. In doing so, the Standing Committee described the model law as having legitimacy and familiarity worldwide and as being an effective framework, noting that nothing about the content of the model law required it to be confined to international commercial arbitration. Substantially uniform laws applying the scheme of the model law to domestic arbitrations were subsequently enacted by the legislature of each state and territory between 2010 and 2017. This was done by taking the text of the model law and enacting it with some modifications and additions to make it applicable to domestic commercial arbitration. So the result in Australia since 2017 has been that the model law in its pure form, as updated in 2006, has applied directly to all international commercial arbitrations by force of Commonwealth legislation, and the text of the model law, with some slight modifications, has applied to all domestic commercial arbitrations by force of uniform state and territory legislation. What is particularly interesting about these reforms at different jurisdictional levels in Australia is how Article 2A and its interpretive approach have been adopted at each level. At the national level in Australia, with respect to international commercial arbitration, Article 2A applies in its pure form. For the domestic arbitration regimes in each state and territory, a slightly varied version of Article 2A has been enacted as Section 2A of each Uniform Domestic Arbitration Act. Article 2A of the model law, it will be recalled, requires regard to be had to the need to promote uniformity in the application of the model law across jurisdictions. Section 2A goes further in requiring regard to be had to the need to promote uniformity between the application of the provisions of the Domestic Arbitration Acts to domestic commercial arbitration and the application of the provisions of the model law to international commercial arbitration. What these legislative developments have meant is that Australia now has both an international commercial arbitration regime and a complementary domestic arbitration regime, each of which is based in a wholesale fashion on the model law, and each of which mandates seeking uniformity and consistency with each other and with the rest of the world in the conduct of international and domestic commercial arbitrations. Since these legislative developments, 3 major cases concerning the model law, either in its updated international form or in its domestic form, have been decided by my court, the High Court of Australia. I was a member of the bench that decided each of these 3 cases, and I was Chief Justice when the second and third of them were decided just last year. I will refer to each of the 3 cases to illustrate how the updating of the model law, and particularly the introduction of Article 2A, has materially affected the ways in which Australian courts have come to interpret and apply the model law. The first of the 3 cases was a case called TCL Air Conditioner and the Judges of the Federal Court of Australia. It was a constitutional challenge to the validity of the provisions of the Commonwealth legislation that gave the model law the force of law in Australia. The challenge was to the ability of the Federal Court of Australia to enforce an award under Article 35 of the model law. It was argued that the enforcement provisions of the model law unconstitutionally vested judicial power in arbitral tribunals. Unanimously, you might think unsurprisingly, the High Court held Article 35 valid, with some members of the court, including me, making specific reference to the requirement to consider its international origin and international application when construing the model law. Particularly illustrative of the theme of my presentation, however, was the related challenge to the arbitral award itself in the full court of the Federal Court of Australia following the High Court's decision. In a judgment delivered by Chief Justice Alsop and Justices Middleton and Foster, the full court of the Federal Court there said, with explicit reference to Article 2A, and I quote, "It is not only appropriate but essential to pay due regard to the reasoned decisions of other countries where their laws are either based on or take their content from international conventions or instruments such as the New York Convention and the model law. It is of the first importance to attempt to create or maintain a degree of international harmony and concordance of approach to international commercial arbitration, such is as reflected of the growing recognition of the harmony of what can be seen as the law of international commerce." The second and third of the three High Court cases decided just last year were of considerable complexity. Both arose under state arbitration legislation applying the model law to domestic arbitrations. Tesseract International Proprietary Limited and Pascal Constructions Proprietary Limited concerned the question of whether Commonwealth and state proportionate liability regimes applied in a domestic arbitration. The question was whether the liability of one party to another party could be proportionately reduced by reference to the alleged concurrent wrongdoing of a third party who was not a party to the arbitration agreement. By majority, the High Court accepted that the liability could be reduced, holding that the inability to join all alleged concurrent wrongdoers to the arbitration did not mean that the substantive rights of the parties were not to be governed by the proportionate liability regimes. The arbitrator was held to have jurisdiction to make an award settling the dispute between the parties by adjusting their substantive liability in accordance with the substantive provisions of the proportionate liability regimes in the same way as could a court. My own reasons for judgment in that case made reference to the foundational principle of party autonomy in the model law, which I explained to be manifested in the model law giving the parties to an arbitration agreement three relevant choices. The first being choice as to the substantive law under Article 28, the second being a choice as to the arbitral procedure under Article 19, and the third being a choice as to the curial law by reference to the seat of arbitration under Article 1.2. Drawing these threads together, I observed that whether an arbitral tribunal can and must apply a particular rule of law in determining a dispute which parties have agreed is to be settled by arbitration turns on the scope and consequence of each of those three choices of the parties and on the relationship between those consequences. I'll give just two examples from this decision of the complexities that can arise and the importance of taking an internationalist approach to the resolution of those complexities. Forgive me if I get into too much technicality, and for those of you who like technicality, forgive me if I gloss over the details. The first example relates to the interplay of the choice as to the arbitral procedure and the choice as to the substantive law. A consideration of the drafting history of the model law shows that the rules of procedure applicable under Article 19 were intended to be carved out of the substantive law chosen under Article 28. This means that the power of an arbitral tribunal to determine a rule of procedure under Article 19.2 of the model law extends to making a procedural order on a topic that would be regarded as governed by a substantive rule of law under the substantive law. This approach, which is the approach I took in Tesseract, was in line with the approach earlier taken by the Court of Appeal of Singapore in a case of Republic of India and Vedanta Resources. The practical significance in Tesseract was that provisions within the domestic proportionate liability schemes prescribing rules of procedure concerning the notification and potential joinder of third parties who were alleged to be concurrent wrongdoers, which would be applicable in proceedings to determine the rights and liability of the parties in a court of competent jurisdiction, were not applicable in the arbitration proceedings. The second example relates to the interplay between the substantive law and the curial law. A submission was made before the High Court in Tesseract that Article 28 of the model law requires the arbitral tribunal to apply the substantive law without any outer limit being imposed to the operation of Article 34(2)(b), which empowers a supervising court to set aside an arbitral award if the court finds in the application of the curial law that the subject matter of the dispute is not capable of settlement by arbitration or the award is in conflict with public policy. On this view that was put to the court, whether the resultant award would be liable to be set aside under Article 34(2)(b)(1) or 2 was a question external to the arbitration in the sense that it was a question which only the supervising court could consider and determine, and not a question which the arbitral tribunal could consider at all. This is an argument I rejected. The view I took was that Article 28 of the model law should not be construed to compel an arbitral tribunal to engage in the futile exercise of applying the substantive law to produce an award which, by reason of its application of that law, would be liable to be set aside by a supervising court under Article 34(2)(b), applying the law or public policy of the place chosen by the parties as the place of arbitration. In adopting this harmonious construction, I referred to a similar approach having been adopted by the Court of Appeal of Singapore in taking the view that an agreement to arbitrate a dispute concerning a non-arbitrable subject matter within the scope of Article 34(2)(b) of the model law would be an agreement that was, if not null and void, at least inoperative or incapable of being performed within the meaning of Article 3.3 of the New York Convention and Article 8 of the model law. This meant that in the circumstances of Tesseract, questions as to whether application of domestic provisions of the proportionality regimes as part of the substantive law under Article 28 would render the dispute non-arbitral or in conflict with public policy would have been capable of being determined by the arbitral tribunal as preliminary questions of jurisdiction under Article 16. I will spare you the third and final decision. You can perhaps read about that in the written version of this paper. I'll come to my conclusion. My theme has been one of dialogue between the international sphere and the domestic sphere in shaping and defining the boundaries of arbitration under the UNCITRAL model law. I have developed that theme in part by explaining how the model law is now applied in Australia to domestic arbitration as well as to international arbitration in a manner that requires the same internationalist approach to be brought to bear on its interpretation and application in each of those contexts. I finish with the words of Andrei Astor, the Hungarian delegate who was largely responsible for the concept of UNCITRAL making it into the General Assembly agenda some 60 years ago. Shortly after its establishment, he wrote that the United Nations, which had until that point only tilled the soil of public international law, was about to set foot upon the land of commercial law, which had been and still was then considered as the reserved domain of sovereign nations. UNCITRAL setting foot in the land of commercial law has been a success. In its pursuit of efficiency, consistency and coherence, it has engendered not only harmony but comity and intellectual rigour. That we are all here is a testament to the world it has helped to build. Thank you.
Thank you, sir. Your address was indeed a treasure trove of wisdom, garnered and gathered through experience and wide reading. Your incisive insights today have pushed the boundaries of legal thought on arbitration. Before we proceed further, I would request Honourable Mr. Justice Subramaniam Prasad, Chairperson Organising Committee DAW and Judge Delhi High Court, Honourable Mr. Justice Sanjeev Narula, Member Organising Committee of DAW and Chair of the Journal Subcommittee and Judge High Court of Delhi, Honourable Mr. Justice Sachin Datta, Member Organising Committee of DAW and Judge High Court of Delhi, and Honourable Mr. Justice Tejas Karya, Member Organising Committee of DAW and also a member of the Journal Subcommittee and Judge High Court of Delhi, to kindly come to the dais for release of the Delhi Arbitration Review. May I now request the honourable dignitaries on the dais to kindly release the Delhi Arbitration Review, the journal of the Delhi International Arbitration Centre, published by the Eastern Book Company, which seeks to foster critical multi-jurisdictional academic research and discussion on contemporary issues in the arbitration world. Thank you so much. The release of the Delhi Arbitration Review 2025 is much more than a culmination of ink on paper. It is a celebration of the limitless possibilities of arbitration in a globalized world which continues to grow by leaps and bounds in the recent times. On this note, may I now request Honourable the Chief Justice of India, Justice Bhushan Ramakrishna Gavai, to kindly deliver the plenary address.
The Honourable Chief Justice of the Australian High Court, Justice Stephen Gegler, the Honourable Chief Justice of Delhi High Court, Justice Devendra Kumar Upadhyay, my esteemed colleagues, my predecessor, the former Chief Justice of India, Honourable Justice Sanjeev Khanna, the former Honourable Judges of the Supreme Court who are present in large number, the judges of Delhi High Court as well as the other high courts, the former judges of the high courts, the learned additional solicitor generals present here, Shri Hariharan, the President of the High Court Bar Association, Shri Vipin Nair, the President of the Supreme Court Advocates on Record Association, Srimati Anju Rati Rana, the Law Secretary, the senior advocates, the members of the bar, and the eminent participants from across the globe. I wholeheartedly welcome all of you to the Delhi Arbitration Weekend 3. In my capacity as the Chief Justice of India, it is my pleasure to extend you a warm welcome to the dignitaries and the delegates from over 20 countries across the globe who honor us with their presence today. It's a matter of great pride for me to inaugurate the third edition of this remarkable event, the Delhi Arbitration Weekend, and to see it evolve into a truly global forum for dialogue, exchange, and collaboration in the field of arbitration. I won't take long because today is a Thursday and I see many lawyers present here in the gathering, and my learned colleagues also. Friends, this is not an ordinary gathering. I think Delhi Arbitration Weekend has a rare exception. And in my knowledge, perhaps the only arbitration gathering hosted by a judiciary of a country. It must be the only event which is jointly organized by the highest court of the country and the High Court of Delhi. It is not often that you find judges inviting lawyers to talk more rather than less. Arbitration, as we all know, is one of those deceptively simple words that lawyers can spend lifetime debating. At its core, arbitration is an age-old human instinct of resolving dispute by entrusting a neutral third party rather than leaving the conflict to foster. As in India, we know that we are having the age-old panchayat system, which could be said to be a foundation of the arbitration. And we also have a merchant guilds in medieval Europe, from the Amitu process of Maasai tribe in Africa to the traditional dispute settlement methods used by Aboriginal societies of Australia. Here I must also acknowledge the Australian arbitration regime with its deep-rooted engagement with customary and modern forms of arbitration, reflecting a long-standing respect for consensual dispute resolution. Most cultures and communities across times have devised their own procedures and practices of arbitration. In many ways, the development of arbitration precedes the development of formal court systems. In the last 80 years, the era after the World War II has seen the development of a largely harmonized global order of arbitration for resolution of commercial disputes. Post-World War II period marks the true beginning of international arbitration as we know it today. The New York Convention of 1958 became the cornerstone, ensuring that arbitral awards could travel across the borders with relative ease. The UNCITRAL model of law of 1985 added uniformity, giving states a blueprint to modernize their arbitral regimes. These developments created, for the first time, a truly transnational legal order in commercial dispute resolution. The architecture of the modern arbitration is built on the edifice of conventions and instruments. However, its true success depends on how national legal systems, particularly the courts and the institutions, embrace and implement them. Undoubtedly, it has been the courts and institutions that have been the harbingers, supporters, and the sentinels of this development. The concept of arbitration has survived the test of time because it balances autonomy with accountability, efficiency with thoroughness, and freedom with fairness. Without credible institutions and vigilant courts, arbitration risks either becoming captive to power or collapsing under mistrust. In the last decade, India has made significant strides in its endeavor to stake its claim on the global arbitration center stage. We have made significant investment in infrastructure, both public and legal. The legislations have received significant attention. The number of arbitral institutions have increased manifold, and the amount of judicial attention towards the field of arbitration has grown exponentially. At the heart of this change lies the growing recognition that strong institutions are the true catalyst of arbitral reform. Institutions not only provide a structured forum for resolution of disputes, but also lend credibility, efficiency, and consistency to the arbitral process. The emergence of Indian arbitral institutions, coupled with the judiciary's supportive stance, has significantly altered perceptions about India as an increasingly reliable jurisdiction for arbitration. In recent years, India's arbitration landscape has grown steadily. With a stronger legal framework and courts taking a supportive role, institutions like DISC have become trusted forums. This has strengthened India's position as a reliable seat for arbitration, attracting parties from home as well as abroad. Particularly in Delhi, DISC was established by the Delhi High Court in 2009, which has lately emerged as a leading arbitration institution. Over the years, DISC has steadily expanded its capacity to handle both domestic as well as international disputes, continually refining the procedures and governance to match global standards. DISC's own statistics reflect this steady rise. In 2024, it disposed of 915 cases and conducted over 15,000 hearings during the year. DISC's evolution reflects a commitment to timely, transparent, and impartial dispute resolution. Over the years, DISC has become a respected forum for parties seeking a credible alternative to traditional court litigation in India. While the road ahead is lengthy, India has sure pace towards its goal of becoming a favorable arbitral designation. Even in Australia, the Australian Centre for International Commercial Arbitration has emerged as a reliable forum by maintaining modern rules with efficient administration and close engagement with the government and professional bodies. Its gradual but steady growth demonstrates that credibility is earned not overnight, but through consistent efforts and transparency. Our own institutions, such as DISC, are on a similar path, and there is much to be learned from the patient institution-led consolidation that Australia has witnessed over the years. In addition to the recent development of arbitral institutes in India, it is also heartening to see the Arbitration Bar of India, a professional association dedicated to advancing alternative dispute mechanisms throughout India, taking steps in setting up task forces on some of the most important issues faced presently by the Indian arbitration regime. These cover a wide canvas of issues, from drafting code of ethics and developing protocols for construction disputes, to looking at reforms in investment treaty arbitration, improving diversity in appointments, and exploring how technology and artificial intelligence can be used responsibly. These steps demonstrate that the arbitration professionals themselves are taking charge of the future, which also highlights that India's arbitration community is not just catching up with global practice, but also contributing in shaping the reforms agenda. Judicial decisions, perhaps more than any other factor, shape the credibility and the trajectory of international arbitration. Legislation may lay the framework, but it is the courts that give life to the law and clarify its ambiguities. In India, this influence is vividly illustrated by a series of recent judgments. Constitution Bench in Core struck down unilateral appointment clauses in public contracts, affirming that equal treatment of the parties is a non-negotiable principle. In Gayatri Balasamy, another Constitution Bench held that the courts cannot modify the substance of arbitral awards. signaling a clear commitment to the finality of awards. Further, Supreme Court in a decision underscored that enforcement of foreign awards may only be refused on the grounds of bias in rarest of the rare cases. The Delhi High Court, in recognizing the legitimacy of a third-party funding, aligned India with global best practices by facilitating across access to arbitration without exposing funders to undue liability. Each of these rulings and many others have had a ripple effect, both domestically as well as internationally. For domestic parties, they strengthen faith in arbitration as an efficient dispute resolution process. For foreign community, they demonstrate that Indian courts have moved away from the interventionist tendencies of the past and now act as guardians of the arbitral procedure. This evolution has not happened overnight. It represents a conscious recalibration by the judiciary in order to align India with the international best practices. The comparison with other jurisdictions is instructive. Australian courts, for instance, have consciously cultivated a reputation for minimal interference, building a framework where arbitration thrives on predictability and restraint. Singapore and the United Kingdom offer similar examples where judicial clarity has been the bedrock of arbitral confidence. India's trajectory shows that we too are learning the same lesson. Judicial restraint is not a sign of abdication, but of maturity and strength. At the same time, the sheer volume of arbitration-related litigation in India reflects a paradox. Parties continue to approach courts not necessarily because they doubt arbitration, but because they trust the judiciary to step in when needed. The challenge lies in maintaining the delicate balance, offering oversight without overreach, support without substitution. Judicial decisions do far more than resolve individual disputes. They shape perceptions and define reputations. They determine whether India is seen as a preferred seat of arbitration. A single pro-arbitration ruling in New Delhi can resonate in boardrooms in London, Singapore, or New York, or Sydney, influencing where parties sit their disputes. That is the true weight of a judicial influence. It goes beyond doctrine into the realm of confidence, credibility, and trust. And let me assure you, India is not just ready for this challenge. The evidence is strong, the arguments compelling, and the verdict unanimous. India is delivering. While we have made significant strides in establishing ourselves as a prominent commercial and legal destination, there's still a room for growth. One area that requires attention is ensuring a level playing field in arbitration between larger corporations and smaller businesses, particularly micro, small, and medium enterprises. Although legislative and policy initiatives have been promising and commendable, it is essential to expedite their implementation and benefits to all stakeholders. By doing so, we can unlock the full potential of arbitration as a tool for commercial efficiency, rather than letting it become a source of prolonged dispute. We are also working hard to confront the question of cost and accessibility and leading by example rather than catching up to the rest of the world. Arbitration is designed to be faster and less procedurally onerous than litigation. While arbitration holds great promise, there is an opportunity to bridge the gap between its potential and the current experience. By addressing challenges like arbitration fees, procedural expenses, and timelines, we can make arbitration more efficient and accessible for all parties. This creates a paradox where the very parties who most need quick and affordable remedies are driven away from arbitration due to the associated expenses. Therefore, by streamlining processes and managing costs, we can unlock the full benefits and potential of arbitration for companies and individuals alike. The spirit of arbitration, or as the French call it, l'esprit d'arbitrage, hinges on a collaborative approach and goes beyond just parties involved. It requires arbitrators, courts, and institutions to proactively identify and discourage unnecessary litigation and speculative claims that aim to harass, delay, or prolong proceedings. Therefore, by prioritizing cooperation or confrontation, we can foster a more credible, dependable, and business-friendly arbitration culture in India. Dialogue among stakeholders is a proven path to achieving this cooperation, ultimately enhancing the efficiency and effectiveness of arbitration process. Today, I believe we are at a tipping point, one that is decisively tipping in the right direction. We can confidently say that India is maturing and developing into a leading arbitration jurisdiction on the global center stage. With our unwavering determination, we are striving to establish ourselves as a preferred global arbitration hub by pushing boundaries and exceeding expectations. The optimism about India's evolving arbitration landscape is also resonated internationally. Recent editions of arbitration weeks worldwide have made India focus panels. The latest White and Case QMUL survey on international arbitration also recognizes New Delhi as an emerging seat of arbitration, alongside other established hubs like London, Singapore, and Geneva. The recognition underscores that the synchronized efforts of the judiciary, the legislature, and the Indian institutions are showing results and reassures us that future of arbitration is indeed bright in India. To achieve our goals, we must invest in capacity building of the stakeholders and strengthen our institutions. The Delhi Arbitration Weekend is itself one of the finest examples of such initiatives. It is not merely a conference, but a forum for exchanging dialogues and refining visions of a shining future. As we inaugurate this year's edition of the Delhi Arbitration Weekend, let us remind ourselves that arbitration is not just a legal mechanism. It is a trust-building exercise, a cornerstone of commercial certainty, and a bridge between cultures and economics. The judiciary and the institutions must continue to work hand in hand, ensuring that this trust is never eroded, but only deepened. Before I conclude, I must place on record my appreciation to the Honorable Chief Justice of Delhi High Court and the Honorable Judges of Delhi High Court, as well as the members of the organizing committee in taking painstaking efforts for making this event a grand success. I have been seeing the Honorable Chief Justice and the members of the committee, the judges and the other law members working tirelessly for last so many months to make today's event a great success. I'm also grateful to the Honorable Chief Justice of Delhi High Court for speaking some good words about me, though I don't know whether I deserve them. With humility and persistence, I have no doubt that we will not only contribute to the global discourse, but also shape it in a meaningful ways. On that note, I thank you all for your presence, your commitment, and your faith in this collective endeavor. May the deliberations of this weekend inspire us, challenge us, and push us closer to the goal of making India as a true leader in international arbitration. Thank you very much.
Thank you so much, sir, for that truly illuminating and thought-provoking address. Your words have not only set the intellectual agenda for this conference, but have also reminded us of the profound responsibility we all share in shaping the future of international arbitration. On this note, may I now request Honorable the Chief Justice of India, Justice Bhushan Ramakrishna Gavai, to present a memento to the Honorable Chief Justice Stephen Gaigler, High Court of Australia. With this, we come to the end of the inaugural session of the third edition of the Delhi Arbitration Weekend. I would like to thank the honorable guests, both on and off the dais, for sparing their valuable time. There's more in store for all of you, though. As our discussions draw to a close, a new musical journey is about to begin. I invite you all to stay on and immerse yourselves in an evening of exquisite Indian classical music. So let us all allow our minds, which have been enriched by the knowledge disseminated by our speakers, to be soothed by the timeless melodies of our heritage. We look forward to sharing this beautiful experience with all of you. I request the guests to be kindly seated. We'll be starting with the musical in a very short while.